Tato, just to confirm, is the presentation moving forward when I click onto the next slide?
You're clicking now.
Yes, so there should be my name and details available.
That's where it is now.
Okay, fantastic. So as I mentioned, I'm Marco Vata. You should know this by now. My contact details are provided to you. The presentation that we're working through today is pretty much identical to the one that I sent through to you via email. I do apologize if there are any mistakes in the presentation. I had to convert everything into a new format, but the content should be the same and hopefully nothing strange has crept through. So my contact number, email address is available there. And also if you click on the link, that is a link that will direct you to the YouTube channel. I'll also send that to you via email once I confirm that the recordings have been posted online for you to access. It is a handy tool to use in preparation for the examination in case you would like to recap on something that we've discussed or that I've said during the course of our workshop. Okay, so just to go through the study material that you will require for the examination purposes. First and foremost will be your holy book, which will be the Patents Act in the amended form. Please make sure that you do use the amended form of the Patents Act, as well as the patent regulations. In previous years, there wasn't any examination based on the patent regulations. However, I do highlight some of the important regulations that you should be familiar with during the course of the workshop, and that will arise during the examination as well. So please don't brush off the regulations. A lot of the timelines dealt with in patent law are provided for in the regulations and not within the Act itself. So those are very, very important. Then your second most important form of study material is the presentation that was distributed to everyone. If you focus on the Act alongside with the presentations that I have provided to you and working through the past examination papers, you should be quite comfortable with the exam and to answer the questions. That is ample study material for you to work through in preparation for the exam. There is just some additional literature that I have added in. Patrice, you have a question?
Yes, I just want to ask, I see you mentioned the exam paper specifically 2020 and 21. Is it
Yes.
worth going through the previous papers as well, or not
Yes,
necessarily?
definitely. No, it is definitely worthwhile. As I mentioned earlier, I've been an examiner for 4 years. This is my 4th year. So there should be 3 past examination papers that was set by myself. So up to 2018, is that correct? Is that you can work through, and even the previous examiners. I mean, the subject matter is the same, so it is definitely beneficial to work through as many as you can. Those are available at the DTIC's website, and I'll see if I can find the link and then share that with all of you as well.
Thank you.
No problem. Then just additional study material is the Dean and Dyer. I don't know if all of you can see this book. It is a book that was authored by some of the partners within Spur and Fisher and was edited by Owen Dean and Alison Dyer, who were the gurus of patent law and copyright law. Even if you don't use this book for study purposes, and I'm not punting this because it's a Spur and Fisher authored book, but it is a very good guideline for IP in general, because it touches on the various forms of IP and gives a very good overview of all forms of intellectual property. So it is a good book just to have handy in future in your own practice and within your workplace, if ever you have anything that arises. Even commercial matters are dealt with in this book. And then again, I guess the Bible for patent law is the Burrell's book. This is a very detailed book on patent law. I don't expect you to study from this book, but it is advisable to turn to the Burrell's book if you have access to it, if there's anything that you may be unfamiliar with and you don't wish to ask me. Okay. Then you'll see in the email that I provided with the study material, I also included 3 articles that I authored. I have, on previous occasions, focused some of my exam questions on the information in those articles that I discussed. So I would emphasize that you do familiarize yourself with the contents of those articles. The one was very relevant at the time, considering the COVID pandemic, which dealt with the licensing and when the government has walk-in rights to patent rights. So that was a very, very interesting article and one that was of relevance at the time. Then lastly, there are citations on case law that you also need to familiarize yourself. These are highlighted in the presentation. If it's not within the presentation, I won't ask any other cases. Okay, so only the cases that are included in the presentation are required for study purposes. There's not many, but I do mention a handful of these. Again, it's also not necessary to know the case off by heart, but at least to know what the crux of the matter was, and then also the findings of the court in that case and how it is relevant to patent law. Any questions so far? Great. If we then move on, we'll be dealing with 9 topics. So the first is the introduction, which we've already gone through. We'll have a brief look at some of the international arrangements. So those are the treaties that are in force where intellectual property and patent law is involved. Probably one of the most important chapters is the 3rd chapter on patentability. About 25% of the examination paper is based on patentability. Okay, so the requirements of patentability, the exclusions from patentability, and so forth. But we'll address these as we move on. But a very, very important chapter to highlight. Then we'll work through procedure. So looking at the filing of a patent application, the various timelines, the payment of renewal fees, acceptance and grant, and so forth. This generally is quite a boring chapter. Unfortunately, it's very procedural, it's very theoretical. So I will excuse you if you start yawning during this chapter, but it is something that we have to work through. But it is also a very important chapter, as you'll see from the past exam papers, where I often ask questions based on the various timelines regarding filing, payment of renewal fees, publication, and so forth. Then moving on to the 5th chapter is the corrections and amendments. So how you would go about correcting or amending a patent specification and an application or a patent itself. Then looking at the rights in and to an invention. So who has the right to file a patent application, how those rights can be devolved, assigned, moved, and so forth. Then we'll briefly look at licensing, both the licensing of the patent in terms of a commercial aspect, as well as compulsory licensing, where the patentee can be forced to license their patent. Looking at the restoration, chapter 8, another important one. There's always a question on restoration in the exam. This is where the patent would have lapsed owing to the non-payment of renewal fees and the requirements in order to restore a patent, as well as the limited rights of the patentee once the patent is restored. Then we'll turn to revocation. This will mostly be dealt with tomorrow, along with licenses and restoration. But revocation is how anyone can attack the validity of the patent and wish to revoke it, so that it is no longer on the patent register. Then we'll briefly look at the infringement provisions and the remedies available. And then appeals, offences, and penalties will mostly be for self-study, so we'll very briefly look through that tomorrow, but we won't spend much time on that. Those are purely for your reading and something that you can attend to on your own. So moving on to the introduction, where did patent law begin? What is patent law? What is a patent? You know, these are things that we're going to be discussing now. And myself being of Italian heritage, I'm very proud to know that the fundamentals and the first form of intellectual property was actually established in Venice back in the Italian Renaissance in the 15th century, as you can see on the presentation in front of you. So in 1416, the first form of a patent was granted in Venice for a structure that was used for fulling wool. So after the wool is sheared off the sheep, it is fulled to clean off any debris and to basically increase the volume of that wool to make it more manageable and to also then develop garments or manufacture garments. And that was one of the first forms of a patent, although no statute relating to a patent was granted or was ratified at this stage. The Venetian government at that stage did provide the founder or the inventor of the structure for this pestle for filling the fabric, who was Sir Franciscus Petri. He granted them a limited monopoly over this invention. Then moving on 5 years in 1421, again in Venice, again, another similar form of a patent was granted for a new boat that was used to transport marble slabs in Venice. For any of you that have been fortunate to visit Venice or Italy, you will see the amount of marble that is used within the churches and structures in Venice itself. So this was a boat that was designed to move the marble along the canals in Venice more readily. And you must remember, back in this era, Venice was the hubbub of Europe. You know, it was a central trading post and a gateway to many parts of Europe and then also into Asia. You know, so a very commoditized economy at that stage in Venice, and with a lot of foreigners visiting. So it was important for these inventors' rights to be protected. But then moving on about 50 years to 1474 was the first form of a codified patent law. And this was known as the Statutes of Industrial Brevets. And as I said, the first form of a patent act that was ever codified. And if we just have a quick look at what was what the translation is of the act itself from the Venetian Patent Statute of 1474, the extract is that each person who will make in the city any new ingenious contrivance not made hereto in our dominion, as soon as it is reduced to perfection, so that it can be used and exercised, shall give notice. It being forbidden to any other to make any other contrivance in the form and resemblance thereof, without the consent and license of the author up to 10 years, who shall infringe, be forced to pay him the sum of 100 ducats, and the contrivance immediately destroyed. Okay, so there's a lot happening in this extract from the statute. But what is remarkable for me is that this is the crux of patent law today itself. There is so much happening within this extract that is still carried through to patent law today. If you consider, it says each person, so any inventor who makes within the city, so a territorial right, so it has to be a territorial right, who makes any new, so there's our novelty requirement for an invention. An invention has to be new in order to be patentable. So any new invention that has not been made before. So there's an absolute novelty requirement, as you'll see is similar to South African patent law and most patent law in the world, as absolute novelty is a common concept across the world. It has to be reduced to perfection. So there's some utility. The invention must be able to work. Again, we'll see as we go through the workshop that there has to be an enabling and utilitarian aspect of an invention so that it can be used and exercised. Okay, so very, very interesting. We've covered a lot of the requirements of patentability just within the sentence that's carried across till today. Again, it's being forbidden. So yeah, we've got the monopoly that is granted to the holder of this right to exclude anybody else from making this invention or any form of this invention without their consent and license. So it's even got some licensing provisions in there, some commercial provisions, and the limited monopoly for a 10-year period. So today, in most countries, there's a 20-year monopoly afforded to the patentee, and even an infringement provision within this act. So if anybody infringes, they are liable to paying 100 ducats at the time, and any infringing product would also have to be destroyed. So it's remarkable to see that from 1474 till today, although our Patents Act has been beefed up, the crux of patent law remains pretty much the same as to what it was back in 1474. So very, very remarkable. A lot of what I've said now might not hit home, but as we work through it, it will make a little bit more sense. So there's just an image of what the statute looks like and the extract that was translated into English that we just worked through. Excuse me for a moment. I just want everyone to consider the reasons behind patent law. And one of the greatest reasons is that it is a tool to drive innovation, okay? Because a patent will become a public document, anyone has access to the document and can make any improvements on that document. It allows for technology to develop. And the reason why I'm highlighting this now is because if we look at the Thomas Edison light bulb that's displayed in the presentation in front of you, you'll see it was a very basic invention. At the time, obviously not, but today we might consider it very rudimentary. But what it contained was an electric lamp for giving light by incandescence, which consisted of a filament, so our filament inside, of a high carbon resistance, and which was set forth within the patent specification. So this was basically the patent claim from this US patent 223898, which was granted to Thomas Edison by the US Patent Office on the 27th of January, 1880. And the point that I'm trying to make with this is that if you look at how rudimentary this invention was from 1818 to the light bulbs that we use today, considering LED lights, xenon lights, halogen lights, it all derived from this invention. And if you take it before that, probably the candle, but it shows that increment in technology and how with the ability of patent law to drive this technology forward. So just a few other fun examples of previously granted patents from the US. So the one on the left, I'm sure, who can tell me what this is for? Anyone?
Lego.
Yes, okay, so that's the Lego brick that was granted a patent. Okay, so as you know, the monopoly is limited, but I also want you to think in terms of other forms of intellectual property. How else do you think this could be protected today?
Trademark.
Yes, great. Thanks, Tato. So today there is still a trademark registration for the Lego brick because a trademark or a shape mark can be protected as a trademark. So although the patent has already expired, the proprietor of this product can still enjoy some form of intellectual property. And back in the day when the novelty wasn't destroyed, there probably could have still been a design registration filed for this as of for the shape and configuration of that brick. Having a look at the one in the middle, that's again the razor blade. And again, to see something that was quite rudimentary to what we use today, you know, with Gillette, and their 4, 5, 6 blades at the moment. And then the first winged aircraft, which was also patented in 1906 to the Wright brothers. Okay, so just some interesting inventions to hopefully whet your appetite and to see what some of the cool inventions are that we can deal with in industry. But then I'd like to home in a little bit into South Africa and to see what is it that South Africans have developed, what have they invented, some cool products that are out there in the world. So one of them being Patentability, which was used on the mission to on the first moon landing. Okay, South African invention. If we have a look at Sasol, some of the technology that Sasol has developed. For your information, Sasol has a huge intellectual property department that sits in-house with, I think, more patent attorneys than what my firm has, for instance. So a lot of development taking place at Sasol in terms of using coal to oil extraction processes. Q20, some more South African inventions. A very important one in the medical field is the CT scanner. And then I'm sure many of you are familiar with the Dolos. Unfortunately, the Dolos was never patented, and a lot of money was lost on that product for the proprietor and the developer of the Dolos. So the Dolos is used along the coastline all across South Africa as a water breaker. But, you know, as you can see, a lot of these inventions are very popular inventions. I think most of these are all known to you. And if you are the sole proprietor of that invention, there is a lot of money that could be made. You know, you can exploit that invention for the monopoly for 20 years in exchange for a reward, because you'll be making, profit and gaining financial advantage from having that monopoly, although limited monopoly, but by not patenting your invention, if you're looking at the dollars, for instance, something that is again used across the world, where the inventor of the dollars lost out on quite a lot, unfortunately. And another very cool South African invention is the creepy crawly. So we have a lot to be proud of in South Africa in terms of the inventions that have arisen within our shores. Thinking of a more recent one is from the University of Pretoria at the medical campus, where the doctor developed by means of a 3D printed ear implant, where all the components for an ear were 3D printed and successfully implanted into a patient. You know, so hammer, anvil, stand, all of that was done at the University of Pretoria for a successful ear implant to restore the patient's hearing. So very cool things that do happen within South Africa shores. So don't think that it is something that is foreign to South Africa. There is development that does take place within South Africa's borders, okay? And why we should always try to advise our clients as best as possible to identify the various forms of intellectual property in the products that they are developing and to see how they can best protect it. Okay, so then we'll just move on to what is the nature of an intellectual property right. So, I mean, intellectual property is a very broad term. It's an umbrella term used to cover all the various forms of intellectual property, you know, namely patents, trademarks, designs, copyright or stage performances, plant breeders' rights, another interesting one, and ones that we shouldn't forget about. But these are all rights that are created through the efforts of human intellect. So all concepts, products, ideas that have been derived from human intellect. All of these rights are creatures of statute, so they are governed by the law, and they are territorial in nature, although there are various bodies in the forms of treaties to allow for easier process and more global protection across the world to protect the various forms of intellectual property. Most of these rights are intangible in their conceptual form, so you granted a patent, it's an intangible thing, but the product of that patent itself can exist in a tangible form. These rights do exist separately from their creator. They are assignable, so there's a commercial value that is added to intellectual property, by either licensing the product, gaining royalties for somebody else to manufacture, to utilize the product. So there is a lot of economic value to be had in intellectual property. As you said, they're all creatures of the law. Whether they're immovable or not for the lawyers, that is debatable. If you are interested in this, you can have a look at the oil well case that that discussed this very topic of whether IP is immovable or not. Any questions so far? No. Okay. Okay, so we've spoken a lot about IP already. We've discussed a lot of patents already, but what is a patent exactly? Does anyone want to give me a definition of what they think intellectual property is? Oh, sorry, what a patent is. Anybody? No takers. Everyone's very quiet this morning. Let's see. Can I pick on somebody? I need some input from somebody, yeah? What is a patent? What is it that we're dealing with this morning?
Shall we go with limited real rights to exploit the product?
Okay, so almost got the nail on the head there. Let's see what Jabulani also has to say.
Something that is new and unique, and also it's able to give a service or to solve a problem or societal problem.
Okay, so that's more defining what an invention is. So an invention is something that is there to solve a problem. It serves some function or purpose to alleviate a problem that somebody might be experiencing. So very close there. Let's see, Jacques, what do you have to say?
I'll take a bash, but I think you pretty much described it there. It's basically a right to an invention that's created by an individual, and obviously it's limited as a result. You can't really give a person a monopoly on such innovation because you could limit it to such an extent that no one can really create or innovate after that. So it's a limited right given to someone for creating something that's new and inventive and has industrial application.
Yeah, so that's quite spot on, Jacques. So it is a right that is granted to either the inventor or the person that has acquired those rights from an inventor for the protection of an invention. Although it is a limited duration for which this monopoly is granted. You must remember that intellectual property is very anti-competitive, and it's not something that is very welcome in an economy to have monopolies. So that's why these monopolies are limited, and it also allows for the further development of innovation. But as you said, it is basically that statutory right that is used to protect an invention. That invention itself has some inherent requirements that have to be met and some extrinsic requirements that have to be met. So by intrinsic requirements for an invention, I mean it has to be an invention per se, but we will touch on that a little bit later on. But then invention also has extrinsic requirements that has to be met. Again, something we'll touch on a little bit later, but those are basically your legal standards that need to be met in order for the invention itself to be patented. And that includes your novelty, inventiveness, and utilitarian requirements. Okay. But what is this right that is granted to a patentee? So that right is a negative right. And why we say it's a negative right is because it doesn't provide the holder with the right to do something. It provides the holder of that right the right to exclude others. So it's an exclusionary right because you're excluding the rest of the public from infringing on your monopoly over that invention. So nobody else but the patentee can exploit those rights, provided unless there is consent given in the form of a license, for instance. Okay, so as Jacques also mentioned, you know, these rights are territorial in nature. So there's no such thing as a worldwide patent. You have to apply in every country where you seek patent protection. And the reason for that is because the rights are granted to you by a country. Okay, every country has their own laws. It's not something, there's no Illuminati that can grant you these rights. Okay, it's the government that provides the patentee with these rights. And this is why they're territorial in nature, and also because of every country's own specific provisions in terms of the law. Okay, but the fundamental principle behind what a patent is the quid pro quo principle. Okay, so it's basically a tit for tat, where the inventor has developed a new invention that they seek to monopolize for a period of 20 years, whereby the government will grant them that right to exclude others from exercising the rights over the invention. But in return, the patentee has to fully disclose the invention. And the patentee can't just disclose it in a way to say this is what the invention is. They have to have an enabling disclosure to say this is how the invention is actually developed, how you would manufacture. You know, so basically considering a scientific paper, for instance, where you've got your materials and methods, setting out the steps in order to obtain the product that is subject to the patent. Okay, so you have to fully disclose what the invention is. And this is something that we've touched on previously. The reason for that disclosure is to allow the rest of the public to see what it is that has been disclosed. How is this invention created? How do I manufacture this invention? And how can I improve on this invention? Okay, so something that you should remember is that for an invention to be patentable, it doesn't need to be something that is groundbreaking, okay? It doesn't need to be a new phone technology. If you consider Apple, when Apple was just released, I mean, it was the craze and the hype was around Apple and what they've developed. It doesn't need to be that, okay? It can be an improvement itself on an already known technology, provided that that improvement has not been known to the public before and that it also meets the inventiveness requirement. Okay, so as we said, something that is very important to remember is this quid pro quo principle that underlines the patent system. So the quid would be the monopoly that is conferred onto the patentee to exclude others from exercising the rights as defined in the Act and infringing on the patentee's rights, whereas the quo is that disclosure of the new knowledge, which is then presented to the public in the form of the patent specification, which includes basically how the invention is developed, how would you manufacture, and then also with a set of claims which defines the scope of protection. But we'll touch on that a little bit more later on. But there is this duality of the patent system, you know, where it's a vehicle for innovation, where some people might argue that these ideas that are created by inventors are something that should belong to the world. But then there's also this clashing world where money is to be made and people should be able to exploit something that they have created, you know, and that they can enjoy the advantage and profit that is accrued to them in the form of a patent. Any questions on this? Jabulani Kurapetse, sorry if I'm mangling your name. I see your hand is still raised. Do you have any questions for me?
Apology, it's the old end. Apology.
Okay, no problem. Your sound is terrible. Perhaps if you have a question, you can type it out in the chat group. We then move on to what the purpose of a patent is. A lot of this is something that we have discussed already. You know, it is there to encourage improvements in technology and by driving innovation. The way this does this is because the patentee can make a profit from the invention by, you know, monopolizing the invention itself and making it available to the marketplace. And, you know, if others see that there is just reward to be had, they might themselves consider developing and improving on existing technology or creating an unknown technology. Okay, it also rewards such improvements by having this monopoly. You can exploit it yourself. And the benefit then from the quo is that there is this public disclosure of the invention for the rest of society to see. And in order to encourage the application of the invention in society and also create a world economy where it is driven by technology and innovation. It also grants you the right to institute infringement action against anyone that might be copying your invention, and allows you that right to defend yourself in court. So it provides you with that locus standi to show that the rights do exist with you and that you exclude others from encroaching on your monopoly. So, you know, as we said, it's a very intangible concept, but the way that I always like to explain it is that you need to consider a patent as you would a house, for instance, or a car. It is an asset that you own. You know, let's maybe not look at a car, let's rather look at a house, okay? Because it exists in a tangible form. You are the owner of that house. And the same as with a patent, it is also a form of an asset. Although an intangible asset, it is still an asset. And a lot of value that can be had in that asset. You know, if you consider a lot of the digital era technologies, considering Google, a lot of their assets are housed in their intellectual property. And I can tell you it's upwards of 70% itself that is housed within their IP. That is where their revenue comes from and the value of their assets. And you can do a lot of reading up on this of companies that have sold their intellectual property to others, and the value that they have garnered from that. You know, and not just from the sale of it, but also the licensing of it. I once heard a joke where somebody said an Apple's actually made up of, an Apple phone is actually made up of Samsung technology, you know, where there's so much licensing that takes place between these corporations, where there's cross licensing of various forms of intellectual property. You know, so a lot of revenue that is generated from the commercialization of the product and the licensing of the product. You know, and as you're able to sell your house, you're also able to sell the product itself. As you're able to rent your house out to a tenant, you're able to license the patent so that anybody else can use it. You know, the licensee can use it. So always draw that analogy between you know, something that is tangible with the intangible product to have a better understanding of how it operates as an asset and the value that can be had in it. Okay, so on the presentation that should be on your screens now is what the patent certificate actually looks like. I can show you one here as well. Yeah, sorry, it's blurring it out. Okay, so just to give you an idea of what is actually granted to the patentee as the proof of the patent specification or the patent right that is granted to them. You know, so that it is a bit more familiar to you instead of just a bunch of words. Okay, so again, just reiterating that a patent is that exclusive right that is granted for an invention, which can either be a new method, a product, or apparatus, a process, or the use of a process that provides a new way of doing things or offers a new technical solution to a problem. And that's what I believe it was Jabulani mentioned earlier. Sorry, I can't recall the name. Let's see. I think we should just break for 10 minutes if that's okay with everyone. So let's see, the time now is 5 to 10. So let's return at 5 past 10. So we'll take a quick 10-minute break, then we'll move on to the next chapter. But before we do so, are there any questions based on what we've discussed so far this morning? Okay, no questions. I will see you all then in 10 minutes time. So please return at 5 past 10. Thanks, everyone. Hey, welcome back, everybody. I think we can get started on with our next chapter of international arrangements now. Are my volunteers back? Thank you very much, Danielle. Thanks, guys. It really makes my life a bit easier this morning, seeing some faces. Thanks, Jacques. I see you disappeared and now you're back again. So good. Has anyone come up with any questions so far that we can quickly attend to before we move on? Okay. You know, I mentioned a lot about the value of intellectual property, and having a quick look during our break at some of the stats. You know, the S&P 500 Global Index that assesses companies and their value indicates that just 2 decades ago, you know, a lot of the top 10 companies were companies that all developed tangible assets. You know, if you consider General Electric, Pfizer, companies that manufactured products were sitting in the top 10 of the S&P 500 companies. Shifting on 20 years to today, those top 10 companies have all been replaced by technology-based companies that all deal with intangible assets whose value is held within their intellectual property. So just to show you that shift from tangible assets to intangible assets within such a short period of time, you know, considering 20 years where the top 10 have all been replaced by technology-driven companies, and considering that 87% of the value of those companies is held within their intellectual property. Although it's very difficult to quantify the value of intellectual property, that is the estimate that's provided, is that 87% of the top 10 countries in the world have their assets sitting in intangible assets, in the form of intellectual property rights. So your patents, trademarks, and so forth. So that should give you a good indication as to why I'm reiterating the value that can exist in the form of intellectual property. Okay, but just moving on then to the international arrangements that govern patent law. We're going to touch on this very briefly, as I think that this is dealt with more extensively in the introductory IP courses offered by SIPL and PEB. So just to recap on these, rather, instead of imparting knowledge in this case, is that there is the Paris Convention for the protection of industrial property rights, which most of you should be familiar with. And there are 3 principles that are provided for in the Paris Convention. The first is that principle of priority right, which means that if you file an application in one country, you have 12 months for patents and trademarks within which to claim that priority date in a foreign jurisdiction. Okay, so any person who has filed an application shall enjoy, for the purpose of filing in a corresponding country, the right to claim that priority date. Okay, so where you filed an application in the United States, you can then still file that application in South Africa within a 12-month period, okay, and claim that priority date. So we'll touch a bit more on what a priority date is a little bit later on, but it's basically the application that was first filed anywhere in the world is your priority application, and where, in terms of patent law, your novelty and inventiveness is adjudicated from that date. So from that first filing date is where a court will assess whether an invention is actually novel and inventive. Then it also provides for the principle of national treatment. So yeah, all the countries that are party to the Paris Convention have to grant the same protection for nationals of other contracting member countries. So if a US citizen wishes to file a patent in South Africa, they should be granted those rights and be treated as if it was one of their own citizens. Okay, so no discrimination between member states, basically. And then, as you'll see, is the common rules, which is a theme throughout the Paris Convention and TRIPS, which is the trade-related aspects of intellectual property rights, is the move towards harmonizing the intellectual property laws within the various countries. So they wish to standardize and harmonize the laws within the various countries. And that is what one of the principles of the Paris Convention and for TRIPS is. So the Paris Convention is administered by the World Intellectual Property Organization, and South Africa was a party to the to the convention since 1947. Okay, if we have a look at TRIPS then, so the trade-related aspects of intellectual property rights, also establishes 3 principles. So the one being the minimum standards. So again, a form of harmonization of the law for contracting parties where minimum standards need to be met for the protection of intellectual property rights in the contracting member countries. Then again, the national treatment, so very similar to the provisions that we see in the Paris Convention. And then also, thirdly, the most favored nation treatment principle, which again, as with the Paris Convention, allows for the non-discrimination between contracting countries and the members of those countries. And so this is the trade-related aspects of intellectual property rights is then overseen by the World Trade Organization. South Africa is a member of the World Trade Organization since 1995 and was a member of GATT, which was established after World War II for the protection and harmonization of intellectual property rights in since 1948. Moving on into the third international arrangement that we'll be looking at, and probably the one that is most relevant for my practice. In my practice, I deal mostly with foreign applicants who seek protection within South Africa for both their patents and design. So I don't really deal with local South African clients. Mine are all foreigners who utilize the PCT to seek protection within South Africa, and also then for design applications, although that isn't within the ambit of the PCT. So what the PCT does is it provides for a unified filing procedure for contracting countries. At present, there's 155 countries that have ratified the PCT, and South Africa has acceded to it in 1998, and it was implemented in South Africa in 1999 by various amendments into the Patents Act. So what the PCT does is it allows for an applicant to file an international patent application with a receiving office. So a receiving office can be one of the local patent offices in the country, which then distributes it to the World Intellectual Property Organization. When you file this application, you will designate an international searching authority. And what they then do is they conduct a search and examination over your patent application. So they will conduct a global search from their databases to assess whether your invention meets the patentability requirements. So is your invention novel? Does it have inventiveness? And can it be applied in trade or industry or agriculture? And they then issue you with a search report or written opinion in which they state whether the invention itself meets the requirements for patentability. So they will actually state that claims 1 to 10 of your invention are novel and claims 13 to 15 are not novel. And you can then address these. Bless you, Nontando. Okay, so that is one of the biggest benefits of filing an international application, is that you are issued with this preliminary search report before you designate and enter the national phase in the various countries across the world. So although it's an international application, it doesn't vest any rights in the applicant. There's no global patent that is granted to you. You still need to enter the national phase in the various contracting states where you wish to seek patent protection. So it affords an opportunity before incurring all these costs by entering into the national countries to already have a clear indication as to whether the invention itself will be able to meet the patentability requirements and whether they will be successful in receiving a granted patent in the various jurisdictions across the world. So the PCT is always a beneficial approach to take and to advise your clients on if they seek protection across a global sphere, if they need to file an application in many countries across the world. Obviously, if there's only 1 or 2 countries, it might be worthwhile filing it directly into a country in terms of the Paris Convention and bypassing PCT, because the costs might be more beneficial by filing directly in terms of Paris Convention as by going the international route. But the benefit then, as I said, of filing a PCT is that you are issued with a research report before incurring all these expenses in the national countries. And you then are also afforded an opportunity to amend your patent specification to try and overcome any objections that were raised in the written opinion by the examiner. We have a question there from Namonde. You're welcome to go ahead.
Good morning, how are you?
Well, in yourself.
Good, thanks. I just wanted to know, I have feedback, I don't know why. I just wanted to know what the process is for a person who seeks to protect their rights from an international point of view. Would they use the Paris Convention first, then the Patent Cooperation Treaty, and then national, or would they do patent cooperation, then Paris, then national?
Okay, so we will have a look at that a little bit later on, but to give you an idea, say you file a provisional patent application. In terms of the rules and the various treaties, if you file directly in another country, that would be in terms of the Paris Convention, where you have to file that application in terms of the Paris Convention within a 12-month period. Also, if you do not file directly and you wish to file a PCT application, that 12-month provision from the Paris Convention is also applicable. So from your earliest priority date, you have 12 months within which to file your PCT application. People can use a combination of these approaches of filing directly or going the PCT route, but it all depends on your client's requirements and the marketplace where they seek to gain patent protection. I mean, if you're considering say a mining technology for diamonds, I mean, there are only so many countries where diamonds may be found and where that technology would actually be applicable. So they need to consider very carefully where they seek to protect their invention. And based on that, they should then do a cost assessment to see, is it worthwhile filing directly into those countries via the Paris Convention, or should they file an international application and then enter nationally at a later stage? So to enter the national phase, once it's gone through the whole international application process, they have to enter the national phase within either 30 or 31 months from the earliest priority date, depending on that country's specific legislation. Does that answer your question?
It does, thank you.
Okay, but we will delve into these timelines a little bit later on today and go into them a bit more detail. But if we have a quick look then at this PCT timeline. So you see, if we start at the beginning here, an invention is created by an inventor. They then file a patent application in their country. You don't have to, you can file a PCT application directly as well. So there's no need to file a provisional or a complete application in a country. You can file a PCT application directly at the receiving office. So as I then said, you appoint your international searching authority. So the patent office that will examine the application for you. You will appoint who you wish to choose. Certain countries have certain searching authorities that they can rely on. So it might be the United States, it could be the European Patent Office, you know, it might be Japan, depending on what that country is aligned with. They then carry out the search of the application and prepare the written opinion. So that is where they will point out any objections they might have and provide you with their report on the patentability of that invention. So you see, by doing this, you then already have a clear indication before incurring all those costs, before filing in the various countries, whether or not it is actually worthwhile to seek patent protection in those countries or not. Okay, and then it goes through to the various international patent offices that you elect, where you have to instruct your agent to file the application for you in the national phase in the various countries to eventually be granted your national patents. Okay, so just remember that there's no international patent that is granted. You know, I can't reiterate enough that there's no such thing as a worldwide patent. You have to nationalize in every country. Okay, there are other treaties that are of relevance as well for clients, you know, considering a repo and a WAPI, which are the more African forms of gaining you know, a broader form of intellectual property, as well as the European Patent Office, where you can designate various countries where your rights are granted instead of entering nationally. But that's a bit beyond the scope of what's necessary for you to know for today. Okay, but as I said as well, during this international phase, if you do get a negative written opinion, so what I mean by a negative one is where the examiner's opinions aren't very good. So they might say that your invention isn't really novel. You are afforded the opportunity to amend it, to overcome any of those objections that are raised by an examiner. You know, so if your first claim for the patent is said to be lacking novelty and your third claim is novel, you know, you are able to amend it by including the third claim into your first claim. To have a novel integer and thereby creating you know, a more positive outcome. So once you do that, you can then request a further examination, which is known as your demand, as you can see over here. So the applicant will file a demand where a further, more in-depth search is conducted, and you're again issued with a IPRP, which is your International Patentability Report, or International Preliminary Report on Patentability is then issued. So again, that is a further examination that takes place, and you'll get a further clearer indication as to whether the amendments you have made or wish to make are more beneficial to the applicant to get a more positive report back. Okay, any questions on this? Nomonde, I see your hand still raised. Is that from previously? Thank you. Gone. Thank you. Okay, but we will look at these timelines in a bit more detail later on today, probably after lunch. They are very important to note, especially for the examination purposes and also in practice. Okay, now moving on to the crux of the work. As I mentioned earlier, about 25% of the examination is based on the patentability chapter. So a very important chapter to take note of. You do need to know the provisions of the patentability extremely well, especially section 25, which is probably the gospel for patent law in South Africa. So please do make a note of section 25, or the provisions in section 25, and the importance thereof, and pay special attention to section 25. It's unlikely that I will ask you to recite section 25 for instance, off by heart. that is what the previous examiners previously done, where you would have to write it out verbatim. I'll try to take a bit more of a practical approach, as you'll see from last year's paper. Okay, but the basic requirements then for obtaining a patent are provided for in section 25(1). And this is basically that the invention must be an invention by definition. That invention must be new and it must involve an inventive step. And then it must also be capable of being used or applied in trade or industry or agriculture. Okay, so these are basically your extrinsic requirements, apart from it being an invention per se, which is your intrinsic requirement. But section 25(1) says that a patent may be granted for any new invention. So that's your novelty requirement. It must be a new invention which involves an inventive step and in which is capable of being applied in trade or industry or agriculture. And that's, as I've just reiterated, yeah. So it has to meet both the intrinsic and extrinsic requirements in order for an invention to be worthy of a patent. And as I said, the intrinsic requirements is basically what that definition of an invention is. So it is that invention has to be an invention that is patentable per se. The previous Patents Act of 1952 defined an invention specifically as any art, process, machine, or composition of matter. That definition has been done away with in the current Patents Act. So previously there was a very specific requirement of what an invention is and defined what an invention is, whereas the current Patents Act has done away with that. Although there is a definition of invention, it's not very clear. It's basically a dictionary definition. But basically in terms of section 25(2), or if we consider section 25(1), it says any new invention. So anything that is new can be considered an invention. However, the Patents Act provides for explicit exclusions from patentability and inventions which are not considered patentable. So the first being from section 25(2) is a discovery, then a scientific theory, a mathematical method, a literary, dramatic, musical or artistic work, or any aesthetic creation, a scheme, a rule or method for performing a mental act, playing a game or doing business, a program for a computer, or the presentation of information. Okay, so anything that doesn't fall within this ambit is capable of being patentable, but also bear in mind that there are further exclusions that we'll touch on later. But this is very important to note that these are the exclusions from patentability and are not considered an invention in terms of the Patents Act. And therefore you won't be granted a patent if your invention per se relates to any one of these exclusions. If we briefly have a look at each one and why these exclusions were included, an invention requires some creative thought of man, so therefore something which existed previously by nature, that was created by nature, cannot be created by man. So what nature has already created cannot be invented, it can only be discovered. So something that is of a natural occurrence cannot be recreated by man, it can only be discovered, and that's why discovery is excluded. It's something that has previously existed, it was just not known to man, and that is why it is excluded. Furthermore, because there is no creative thought involved in this discovery. It's not something that a person with their own intellect has devolved. Then moving on to scientific theories. So again, a scientific theory is just a method of explaining something that exists in the natural world. So it's a logical summary of how something in the natural world operates or exists, and again, why it is excluded from patentability. The same is applicable to mathematical methods. Looking at the theorem of Pythagoras as an example, it's again a summary or a way of explaining how something works in the natural world. Then turning to literary works, artistic works, musical creations, aesthetic creations, these are all protected by the Copyright Act, as well as the Designs Act for aesthetic creations. Okay, so this is the reason why they're excluded from patentability, because there is sui generis law that provides for a monopoly over those forms of intellectual property rights. Okay, moving on to schemes, method of doing business. These are also excluded because, again, these are essentially mental steps that are taken. It's not something that is created with your own ingenuity and the application of one's own mind. So as an example, there is just the rules of a board game. For example, the rules for Cards Against Humanity, or the rules for Monopoly, or 30 Seconds. Okay, those are not capable of patent protection, although there might be some copyright that may exist in those rules. So again, just because it's not applicable to patent law doesn't mean it can't be protected in another form of intellectual property. Again, when it comes to a method of playing a game, it doesn't mean that the parts to that game, the pieces, might not be patentable, or the board that might be subject to design protection. Okay. Tato, you're shaking your head there. You look a bit puzzled. No. Okay, then moving on to computer programs, one that's very important and that is often of much debate in the patent fraternity is whether a computer program is patentable or not. While it is excluded in terms of the Patents Act because, again, a computer program is defined as a work in the Copyright Act. So the computer program itself is protectable as copyright, but not as a patent. But remember that the copyright only extends to the source code. So the approach that is taken in Europe is that there is some technical effect where a computer program is used in order to solve, a problem where it has this technical effect, and it describes subject matter that, does garner some advantage to fulfill a purpose. So not just the underlying source code itself. So where the computer program is used within a system, that might be considered to be patentable. And that is what was held by the boards of appeal in Europe. So one thing that's also important to note is that Section 25(3) says that these exclusions need to be interpreted narrowly. So if we have a look at Section 25(3), it says this provisions of subsection 2, so those are the exclusions we just dealt with, shall prevent only to the extent to which a patent or an application for a patent relates to that thing as such, anything from being treated as an invention for the purposes of this act. So quite a mouthful there, but what it actually just says is that those provisions should be interpreted in a narrow fashion. Okay, unfortunately, there's no case law in South Africa that has ever dealt with these exclusions or the narrow interpretation that is applicable to those exclusions. But as I said, the Boards of Appeal of the European Patent Office says that there is a requirement of a technical effect. So if a patent describes subject matter from the excluded categories in subsection 2, and it provides a specific technical result, then it may be capable of patent protection. Okay. You'll see that I did write an article on one of those, so do have a look at that in a bit more detail, where it's explained a bit better and also draws a distinction between what is protectable as copyright and what is protectable as a patent, or in the form of a patent. Any questions that you might have so far? Okay, so I mean, it is quite straightforward. If you understand the reasons behind those exclusions, it makes a whole lot more sense. Okay, but then in addition to Section 25(2), there are some further exclusions from patentability and this is provided for in section 25.4 as the first one that we're going to discuss now. It says that a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. So if the invention would encourage offensive behavior or immoral behavior, then it would not be subject to patentability. One example that would fall within that ambit would be a date rape drug, for instance, where the sole purpose of that product is as a date rape drug. That is clearly immoral behavior and not part of patentable, would not be able to garner patent protection. Another one would be stem cell related inventions, where it might also be considered immoral, although some might not find it immoral. It's a very debatable topic. It's a very subjective thing for the court or the patentee or the registrar of patents to consider whether it would actually exploit, encourage offensive or immoral behavior. Very, very subjective from person to person. Okay. Moving on into section 25.4b. A patent shall not be granted for any variety of animal or plant or any essentially biological process for the production of animals or plants, not being a microbiological process or the product of such a process. And what this essentially says is that it is not possible to gain a patent for instance, a new species. So if you take your poodle and crossbreed it with, a Yorkie, whatever you create there, that is not capable of patentability. Okay, it's essentially a biological process. So even when you crossbreed to select for specific traits that are expressed in the genes, that will also not be capable of patentability. Okay, it's an essentially biological process. So also considering a new variety of a rose, if you cross one rose, and I mean by a plant, with another to form a new variety of a rose, that is catered for, but in terms of the Plant Breeders' Rights Act, where a new variety of a plant can be protected as a plant breeder's right. Okay, and that is done by way of genetic manipulation or by crossbreeding, hybridization. So that's the reason why the plants are excluded from the Patents Act, is because there is sui generis law in terms of the Plant Breeders' Rights Act for the protection of the variety of plants and trees. Okay. However, it goes on further to say not being a microbiological process or product of such a process. And what this does is it confirms that the development of an antibiotic, for instance, where there's a microbiological process at play in the product of that microbiological process. So, as I said, the cultivation of a microorganism to produce a product such as an antibiotic that is capable of patent protection. Okay. So a microbiological process is capable of patent protection, as well as the products of that process, such as your antibiotics. Any questions on that section? No. Okay. Then moving on to, let me just reiterate Regulation 28A. This relates to the Budapest Treaty and the depositing of microorganisms. So the Budapest Treaty provides that if your invention relates to a microbiological organism, the process of a microbiological organism or the product of that microbiological organism, that microorganism needs to be deposited at a facility that is capable of storing or cryopreserving that microorganism, so that any person is able to access that microorganism for further development. Once the patent expires, they should have access to that microorganism. And it requires that if that invention relates to a microorganism or that product, that there should be provision made in the patent specification for the accession number. So it's basically the deposit code. So once you deposit the microorganism at the facility, you're provided with a certificate to say, this microorganism is housed within this facility, and this is the number in order to trace it at that facility where it is being preserved. It is also a ground of revocation if your invention does relate to a microorganism or the product of that microorganism, and you do not fulfill the requirements of providing the succession number in your patent application, then the patent can be revoked at a later stage should you not fulfill this requirement. So something important to take note of there. Then looking at section 36, the registrar may refuse. Okay, so the registrar of patents has discretion here to refuse an invention which is contrary to well-established laws. For example, a perpetual motion machine. It's not possible to input a certain amount of energy and have that energy not be given off in another form where there is a loss of energy. It's naturally not possible in terms of Newton's laws of motion. So if an invention relates to that, the registrar of patents may refuse such an invention. Again, he also has the discretion to refuse the invention which could encourage offensive or immoral behavior. I'm not entirely certain why this provision is provided for twice, because it would seem that it's not patentable, but that he also has discretion to allow or refuse that invention. And then also inventions which may be used in a manner contrary to law. So if, again, invention relates to, example, a biochemical weapon that will be used in warfare, the registrar has the power to refuse such an invention from being granted. Then also just take note that there is specific requirements that relate to nuclear technology. So any invention which relates to a nuclear technology has additional requirements that must be met in order for a patent to be granted. So if an application is filed for an invention that relates to nuclear technology, in terms of the Nuclear Energy Act, which then comes into play, you have to notify the Minister of Mineral Resources and Energy that you are filing this application. You have to provide the Minister of Mineral Energy and Resources a copy of the patent specification. He will then himself also work through that patent specification and will advise the registrar whether this may be prosecuted further in South Africa or not. So yeah, there's a power shift from the registrar of patents to the Minister of Mineral Resources and Energy. Okay. These do arise quite often in practice, especially from abroad, but I've never had a case where it has been disallowed or refused by the minister. Okay, but that is just something you need to be aware of as well, is that where it does relate to nuclear energy, there are specific provisions that come to play, and that the minister is also obliged to maintain the secrecy of that invention when he is dealing with it. Okay, then moving on to another exception from patentability. So there is quite an extensive list, but this is a very important one in practice, and that is the method of treatment, as we refer to it in the industry. So section 2511 provides that an invention of a method of treatment of the human or animal body by surgery or therapy or of diagnosis practiced on the human or animal body shall be deemed not being capable of being used or applied in trade or industry or agriculture. So where the invention relates to a form of surgery where, say, for instance, a medical practitioner has developed a new way of conducting a surgery to remove an appendix, that is not patentable. And specific reason for that is because if that right is granted to this doctor, only he has the right to follow that approach. So it hinders medical doctors and veterinarians from actually performing the duties that they should be allowed to carry out and to fulfill their oath. Okay, so very important to take note of this provision, especially for examination purposes as well. Any questions so far on the method of treatment? Okay, so you'll see that it doesn't just apply to treatment, or it is treatment, but by way of either surgery or therapy or diagnosis. So if you develop a pharmaceutical compound for the treatment of for cancer, administering that drug is considered a method of therapy, or even, you know, a method of diagnosing a patient for a certain disease would then also not be allowable in South Africa. And the reason why I said that this is a very important exclusion, especially in practice, is because method of treatment is allowable in America, for instance. So where an invention arises in America and it is then filed in South Africa, you know, they run the risk of sitting with an invalid patent, specifically because of this provision where the claims relate to a method of treating a patient for cancer, and that is not allowable in South African law. Are there any questions on this? Nothing. Okay, but the compounds and compositions for use. So if there's the development of a pharmaceutical which is used in such a medical treatment is, however, patentable. So if the surgeon develops a new surgical tool, he can obtain a patent for that surgical tool. Or if he creates a drug for the treatment of something, that drug itself is patentable. Okay, and this applies to both first and medical, second medical uses of a known compound or composition. There was a case that dealt with, with method of treatment claims in South Africa, and that's the Elon transdermal case. And what this case held was that, that the first medical use of a known compound. So if a practitioner or an inventor has developed a new compound, then in the patent specification, that compound has to be claimed in a specific format, which is known as your first for use type claim format, okay, where he has to claim the compound as a compound X, so whatever that compound is, for use in the treatment of whatever disease it is in the patient. So again, this reiterates that compounds and compositions are allowable in the use of a treatment, okay. So a compound X, so say paracetamol, for use in the treatment of the disease of a headache in a patient, is allowable. And the courts have sanctioned that this is the format that must be used, where that compound that's the first time that it has been brought into the public domain. However, that use of the same compound for a different use can be patentable. Okay, so say if we take the example of paracetamol again, which is salicylic acid, that is the salicylic acid, is the main component for the treatment of headaches, for instance. That can still be patentable if the use is found to be a use for something else. So as a blood thinner, for instance. Okay, so it's the same compound that is being used, but for different treatments. Then that is still a patentable invention. Although the compound is already known, the use may not have been known, and that will give it its novelty. Okay. Hi, Jacques.
I've got a question for you. So I know in Europe and the US, or mostly in the US, there was this practice of evergreening, where they would take a patent or a patent for a drug, and then close to the end of its period, they would apply for another patent for another use, for example, exactly like you explained now. And inevitably, they extend the patent period, and I think they called it evergreening.
Yeah.
And I know that in India, they changed their legislation to disallow for this, and they got a lot of backlash. But I mean, obviously, India is known as the generic producer of the world.
Yeah.
What's South Africa's stance on this, or how is it approached here?
So this is probably something I should have mentioned previously, is that South Africa is a non-examining country. So you can file a patent application in South Africa for the wheel, which has been in existence for millennia. And you will be granted that patent. Whether it's enforceable is a different story, and whether it's valid is a different story. But look, the South African approach is a difficult one to comment on, really, because they're two minds of thought. There are those that favor the patentee, and then there are also those that don't. Most of these patentees for pharmaceuticals are big corporations, such as your Adcox and that. But if you file that application in South Africa, it will be granted. So the Register of Patents doesn't take an active step to actually examine what the contents of that specification invention is. But there are lobbyists in South Africa that are obviously against evergreening, which you explained. But you also need to consider what the law says and what the requirements of patentability is, and specifically in terms of these provisions. So if it is something that is new, and as I said, it doesn't have to be a groundbreaking development. If it is something new, in terms of the Patents Act, you should be afforded those rights, even if it is for new treatment. And then, I mean, specifically, there is the use, let me get to section 25.9 quickly so that I can show it to you. Yeah, if we have a look at section 25.9, where there has been a disclosure, so your compound is already known in the market, in the public domain. This compound is known, but it doesn't destroy the novelty for that invention. And this is in terms of section 25.9, where we look at second medical use of a known compound, which is basically what I'm discussing at the moment. And this section says that in the case of an invention consisting of a substance or composition, so your salicylic acid for paracetamol or Disprin, for the use in the method of treatment, so where it is used for treating the human or the animal by surgery, therapy, or diagnosis, and it's practice on that human or animal. The fact that that substance is already known, that it's already been disclosed, and forms part of the state of the art, which is everything that is available in the public domain that relates to that technology before the priority date of that invention, shall not prevent a patent from being granted for that invention if the use, okay, so if the use of that substance does not form part of the state of the art. Okay, so that basically answers your question, that in South Africa, that provision is allowable. And, another practice that is also of contention is the filing of divisional patent applications, which some people say you're also extending the life of a patent by filing a divisional application, another divisional application. But your monopoly is still based on the initial filing date as well. So, but we'll look at divisional applications later on and bring this topic up again. But a lot of these lobbyists are also not really familiar with what the law says. Okay, and although the law might seem unethical, it is as it stands and needs to be brought to the courts or legislature to be ratified if necessary, or corrected or amended. Okay, but in South Africa it is permissible. So where that compound is known, that compound does form part of the state of the art, So it is available in the public domain. If that use is a new use which wasn't in existence before, so that compound was never used for the treatment, for a new treatment, then it is still patentable. Does that make sense?
Thanks. Yes.
Okay, so just remember, although the compound already exists, if the use of that compound is for something else, then you can obtain a patent for that. So yeah, as you said, India is very anti-evergreening, and a lot of things they completely disallow in India when it comes to pharmaceuticals. It's very difficult to obtain a granted patent in India for pharmaceutical. And as you said, it's because a lot of their economy is driven by this pharmaceutical industry that creates the generic drugs. Nomonde, you have a question? Nomonde's gone.
Sorry, I didn't unmute myself.
No problem.
I was wondering if Section 25(9) allows for subsequent usage beyond the second medical use, or is it limited to just that? So if a third use was found.
Yes, no, so even it doesn't matter how many uses, that provision will still be applicable. So you will still be able to obtain an invention, even if it's the third, fourth, fifth to infinitum, you would be able to obtain a patent, provided that the use and the treatment of a specific condition was not previously known by using that composition or drug.
Perfect, thank you.
No problem. Okay, but then just going back onto the form that should be used when drafting a patent specification and what the courts have held in South Africa. So if that compound is being disclosed for the first time, it should follow this format of the compound for use in the treatment of whatever the disease may be in the patient. However, the courts had said in South Africa, if it's a second medical use, so if that same compound is being used for the treatment of a different disease, then you have to follow the Swiss type format claim in South Africa. And that is that the use of the compound X, so you're using the compound, so salicylic acid or salicylic acid, in the manufacture of a medicament to treat whatever that disease might be. So to treat, thick blood. So you see the style that is used is very different. You're directing your claim towards the compound, whereas it's towards the use of that compound. Okay. Everyone seems a bit lost. Any questions? Tato, do you have a question for me? You pondering this?
I do. Maybe I'm unnecessarily mixing stuff up. So the Swiss type claim does not necessarily mean okay, maybe okay. Having a Swiss type claim doesn't necessarily mean evergreening, right? Because from my understanding, evergreening means, for instance, I have a medicine that's an oral suspension, and then I use the compound in that medicine to turn it into like a tablet form.
Yeah.
And then second medical use is that same suspension used. So let's say it was used for, let's say, let's use a practical example, thalidomide. It was used for morning sickness. Then they found that it has teratogenic effects, and then they used it for treating cancer.
Yes.
Is that the right way to?
Yeah, that's correct. Yeah.
Okay.
No, you've hit the nail on the head there. Okay, so you're getting that quite well. Okay. Good stuff. So this is what is the law in South Africa when it comes to first and medical use of a known compound. The approach that's taken in Europe is slightly different. Recently, the European Patent Commission, they held that even the second medical use must be claimed in the for use type format. So Europe has completely done away with the Swiss type claim format that is applicable in South Africa. So just something to be considerate of. And what we do in practice is, because South African courts often follow a European approach, and to err on the side of caution, when we're drafting the patent specification or amending it, if it is for second medical use claim, we will also include a for use type claim, just to cover our bases if the court ever decides differently in South Africa. Okay, so it may well be that when South African court is ever faced with the interpretation of this type of claim, that they may then follow the approach of Europe. So that's just something that we do in practice. I don't know if it's all the firms that do that, but it is an approach that we follow, is that if the compound is a known compound used for second medical treatment or third medical treatment, so on, that we include both for use and Swiss type claims. Okay, so just something to keep in mind. Okay, so just some reasons, and again, an example that I've been using is the salicylic acid that's used for the treatment of headaches. So salicylic acid was first discovered, and that was used for the treatment of headaches. It's the first use of that compound. So you'll see it is the compound for use in the treatment of that disease. Although the headache's not really a disease, it's more symptom, but you get the gist of it. Okay, then second use, so the use of salicylic acid for the manufacture of a medicament. So this is the wording that must be included in this type of claim. It's that compound that's used in the manufacture of that medicament for the treatment of hypercoagulability. Okay, so that's where blood clots arise. So it's for the treatment of, or prevention rather, of blood clots. And how does this arise? I mean, so it could be that the drug has initially been developed for a particular purpose, and then later research finds that it is applicable in another therapeutic area. It could be that the drug failed what it was set out to treat, but that the new results indicates another form of treatment. Or sometimes a compound for non-medical use is found effective for medical use, such as marijuana. Okay, so if you think about marijuana, people have been smoking it to get high, but now, the extracts of CBD are being used for all forms of treatment. Okay, so if it is used for a different treatment that's not yet known, then that could be patentable. Tato, your hand was up.
Yes, I just wanted to find out, for the second medical use, how far removed from let's say the initial symptom would a medicine have to be to pass the bar of inventiveness? So for instance, salicylic acid for headaches, or let's say it was treating some localized pain, and then the second medical use was for like generalized pain.
Yeah.
The fact that it's
so that's
pain.
like I said, this example is not really great because that's more of a symptom than an actual disease. So it would probably be from a disease that's defined in one of the medical books. So I mean, pain, you're treating pain, which is a symptom. It's not really a disease itself. Okay, does that make sense? So like I said, not a very, very good example. It should be a medically approved disease itself. Okay, any questions that you might have? Jabulani, you've got a question for me.
I have a contribution.
Yes.
One of them is Viagra. It was actually meant to treat some other medication, but later on they found out during the clinical phase that was actually good for treating male impotence.
Yes. Yeah, that's actually a very, very good example, and that's very true what you're saying, correct. That Viagra is one of these specific compounds where, it's a compound that is in existence. I can't remember what was the initial use of the Viagra. It was for blood pressure, right?
Yeah.
Yes. Yeah.
Yes,
so
for
it
blood
was
pressure.
used for impotence or erectile dysfunction. So a very, very good example that you gave there. I think I'll use that one next year in the slides. So thanks for that, Jabulani. Any other questions that you might have on this? No, okay. So that basically concludes all the exclusions from patentability and the intrinsic requirements that invention must meet in order to be considered patentable. We're then going to move on to the extrinsic requirements. So the extrinsic requirements, as I mentioned earlier this morning, are the legal standards that an invention must meet in order to be patentable. So these are the statutory provisions in order for that invention to be patentable. So the first being novelty, the second being non-obviousness or inventiveness. Those words are used interchangeably, so it has the same meaning. And then it must be capable of being applied in trade or industry or agriculture. So if we have a look again at section 25.1, these extrinsic requirements are included in section 25.1, where it says a patent may, subject to the provisions of the section, be granted for any new invention. So it must have the novelty, which involves an inventive step and which is capable of being used or applied in trade or industry or agriculture. So it's a very basic concept in patent law worldwide that an invention must be new before its priority date in order for that patent to be valid. So an invention is not deemed new if it does not form part of the prior art immediately before the priority date of that invention. So as I said, the prior art is basically all the technology that relates to that invention that is available in the public domain. So any disclosure that has been made will form part of the prior art. So anything before the filing dates for that invention is then considered prior art. Okay, and the priority date, as I said, we'll define that. So the priority date is the date on which the first patent application has been filed for which an invention is disclosed anywhere in the world. Okay, so it doesn't have to be in South Africa, it's anywhere in the world. So if I filed a patent application in the United States, that will be the priority filing date, will be the US filing date. Okay, and that again is what I said, where the courts will adjudicate on novelty and inventiveness. They will consider the prior art before that filing date. Okay, so this is why it's very important to file your application as soon as you're possibly able to ensure that you secure your priority date. Section 25.5 defines what novelty is. So it says an invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of that invention. Okay. So again, just reiterating what we have already said. So anything which does not form part of the state of the art will be considered novel. Then section 25.6 provides us with the definition of prior art, or what the state of the art is. So state of the art and prior art are again words that are used interchangeably. And section 25.6 says that the state of the art shall comprise all matter, and this can be a product, a process, information, anything really which has been made available to the public. And the public is not only South Africa, it's anywhere in the world, by written or oral description, by use, or in any other way. So basically any disclosure that has been made available anywhere in the world is considered prior art. So as you can see, just some examples of prior art. So it can be me presenting a lecture to you guys about something that I've developed that would consider prior art. The presentation that I'm giving would be considered prior art. So any publication, television, radio programs, literally anything where there is some disclosure to the public will form part of the prior art. As I said, this disclosure must be made available to the public. So if you have written a document setting out what your invention is, but that document is never made publicly available, then it is not considered prior art. And again, just to reiterate that it can be anywhere in the world. It's not located to South Africa only. It's a worldwide provision. And then again, this is just known as absolute novelty. Hi, Tato.
Hi, Marco. I came across it's either European or US case where what was cited as prior art was like a cartoon, an animated cartoon from like the 1920s, where the invention was fictional under those circumstances. So I just wanted to know, for under those circumstances, when you're comparing the prior art to the invention being claimed, how exactly are they drawing the essential integers of this this prior art? How do they determine?
Yeah, that's a very difficult one. I mean, there's even been instances of Star Trek, for instance, or Star Wars, you know, where some of the inventions that they've used in these films have also been brought up as prior art before in court cases in the US. It's only in America that these types of things happen, but it also depends on that country and their specific provisions. You know, in South Africa, just disclosing something doesn't necessarily mean it's an enabling disclosure that enables somebody that is skilled in that technology to actually perform that invention. You know, so if it's not really an enabling disclosure, it's not really of that much relevance. You know, you've got to be able to perform that invention, you know, and it has to describe it wholly. So all those essential integers, all the integers have to be present in that prior art document. So, you know, if it's not, then it won't really destroy the novelty of it, because remember, you only need to have one essential or one integer that is novel to be patentable. Okay. I don't think I really answer your question, because it is very difficult to provide a definition based on something from overseas. But you know, in terms of South African law, it must be an enabling disclosure. Okay. Okay, and all those integers have to be present in order to destroy the novelty of that invention. Okay. Does that help? Yeah, great stuff. I just quickly want to move on to something. Okay, so we now know that novelty is a very important extrinsic requirement that has to be met for an invention to be considered patentable. However, there are several exceptions that relate to novelty, and there are exceptions that deal with where there hasn't been disclosure, so where the novel destroying or normally novelly destroying document or disclosure would not actually destroy the novelty. So there's been no disclosure previously, but it does actually destroy the novelty. Then there's a further exception where there is disclosure, but it doesn't destroy the novelty. Okay, so that would be your second medical use as an example, where there has been a disclosure of the compound itself, but it doesn't destroy the novelty of the invention due to the fact that it's for a second medical use. Okay, so if we have a look at some of these exceptions to novelty where there hasn't been any disclosure, but it does destroy the novelty. The first one is in terms of section 25.7 that relates to prior patent applications. And what this section says is that the state of the art shall comprise matter contained in an application. So whatever has been included in this application for a patent shall be considered prior art, open to public inspection for a patent, notwithstanding that the application was lodged at the patent office and became open to public inspection on or after the priority date of the relevant invention, if the matter was contained in that application both as lodged and as open to public inspection, and the priority date of that matter is earlier than that of the invention. Okay, so this is quite a mouthful again to take in, and I think the legislature really could have drafted this a bit better. But what it says is that if you file a patent application at the patent office in South Africa, and it's not yet open to public inspection, and so party A files a patent application that's not yet open to public inspection, then party B comes afterwards and files another invention, another patent application for the same invention at a later date. Even though this application is not yet open to public inspection, it is considered prior art only if it becomes open to public inspection. So once it is granted, okay. So party B would not have been aware of this prior patent application because it's not yet open to public inspection. But if it does become open to public inspection, it will be considered prior art against party B's application. Does that make sense? Okay. So let's just to recap that. So as I set out here, in other words, if there are two co-pending patent applications at the South African Patent Office, very important to note that this is only applicable to South African patent applications. Then the one with the earliest filing date is considered to be novelty destroying in respect of the second later filed application, even though not publicly available at the priority date. Okay, so if we consider it from a global perspective, if party A filed a patent application in the United States of America, which is not yet granted, so it's not yet available to the public, nobody can access that document but the officials at the patent office, and party B files a patent application in South Africa for the same invention after this filing date in the United States, this application will not be considered prior art, even if it is granted. It will only form part of the state of the art once it is granted, which will likely be after the filing date of party B's application. Okay. However, if party A filed a patent application in South Africa for an invention and party B filed a patent application after A, even though party A's application is not yet publicly available, it will be considered prior art against party B's invention. Okay, so do you see the distinction between the two? Tato, you're frowning very much. Nicole, let's hear what you have to say.
Hi, Marco. Thank you so
Hi.
much. I just want to find out, will it only be, as you mentioned, then from the date of publication?
Are you talking if they're both filed at South Africa Patent Office?
Yes.
No, so the priority date is then considered as the date of publication, basically.
Okay.
I mean, it does seem a bit unfair because if you are party B and you're filing this application, you're completely unaware that there is this application that already exists at the patent office. You know, so it does seem a bit fair. But this prior filed application with an earlier priority date is then does form part of the state of the art. So remember that novelty and inventiveness are adjudicated from the priority date of applications. Hi, Jacques.
Sorry, Margaret, just a quick one. If application A is not accepted, does that still amount to novelty destroying for application B?
No, so it won't. So if that first application never proceeds to grant, if it never becomes publicly available, then it won't form part of the state of the art. So that's the caveat. It has to become publicly available at a later stage. And that would generally be by way of grant. Okay. Tato, are you happy? Okay. Okay, if we then move on to another exception to novelty where there hasn't been disclosure, but it is novelty destroying, that would be your provision in terms of section 25(8) that relates to secret commercial use. And this section provides that an invention used secretly and on a commercial scale within the Republic shall also be deemed to form part of the state of the art. So if you consider, for instance, a trade secret, if a company is manufacturing or has a process of drying paper, for instance, and that process of drying paper is used as a trade secret, but they are using it on a commercial scale, even though it is a trade secret and it's not publicly available, that will be considered prior art when the court has to adjudicate on the novelty of the invention. Okay, so secret commercial use. But what is important to note about this provision is that it is limited to use in South Africa, and it must be on a commercial scale. It doesn't affect inventiveness whatsoever. It's limited to novelty only. Okay, so this will not be considered prior art against inventiveness. It will only be considered prior art when considering novelty. Okay, so if this method of drying paper, which is being used as a trade secret where it is done for commercial purposes, if that is done in Botswana or Namibia or United States, it will not be considered prior art. However, if this process takes place within South Africa, it is then deemed to form part of the state of the art. Okay, so just a few important things to take note of there. So it has to be used secretly, it has to be on a commercial scale, and it has to be within the Republic of South Africa. Okay, then if we move on to the further exceptions of novelty, this is in cases where there is a disclosure of the invention or the integers of the invention, but is not considered to be novelty destroying. So the one that we've discussed at length is section 25(9), which is the second medical use provision. So again, if the composition or compound is known for the treatment of a disease, it will not be novelty destroying if the use is for a new use. Okay, so if we just want to read through this section, in the case of an invention consisting of a substance or composition for use in the method of treatment or animal body by surgery or therapy, or of diagnosis practiced on a human or animal body, the fact that the substance or composition forms part of the state of the art immediately before the priority date of the invention shall not prevent a patent being granted for the invention if the use of the substance or composition does not form part of the state of the art. Okay, so if the use is not yet known, then it will still be patentable, and the disclosure of that compound or composition will not destroy the novelty for this invention. Then if we move on to the last exceptions to novelty, this is where there is prior knowledge or the publication of the invention that has been excused in terms of section 26. So this provision provides that a patent shall not be invalid by reason only of the fact that that invention in respect of which the patent was granted or any part thereof was disclosed, used or known prior to the priority date of the invention. So it's basically saying where there has been a disclosure prior to the priority date for the invention, it will be excused if the patentee or his predecessor in title, so if the patentee or anybody that has obtained the rights to the invention can prove that such knowledge was acquired or such disclosure or use was made without his knowledge or consent, and that that knowledge acquired or the matter disclosed or used was derived from him or her, and if he or she learnt of the disclosure, use, or knowledge before the priority date of the invention, that he or she applied for and obtained protection for his or her invention with all reasonable diligence after learning of the disclosure. So again, a lot going on here. But what this basically provides for is if somebody has acquired the knowledge or the use relating to that invention without the knowledge or consent of the rightful proprietor to that knowledge, that disclosure will not invalidate the patent, provided that as soon as the owner of that invention is made aware of this disclosure, that they seek to obtain patent protection as soon as possible with all due diligence as is provided for in the Act. Okay, so if your neighbor comes over for a braai one night and they make photocopies of your work, your notes regarding your invention, and they go ahead and disclose it, you found out that your neighbor has stolen your notes, you have to apply for that application with all reasonable diligence. Okay, everyone following there? So it's where there's been an unlawful acquisition, basically, of that knowledge without the proprietor's consent. If that does happen, the proprietor has to seek patent protection as within reasonable time. Then moving on to the next one. Hi, Tato.
Just one more question on novelty. Under Section 80, I know the minister can acquire inventions or require that they be kept secret and then use them if it's in the interest of the state. So I'm wondering if you're an applicant and your invention is acquired in that way, let's say by the Minister of Defense, like it says in the section, and another applicant comes to make an application because it's used in secret, it's acquired in secret, it's never published. So is that novelty destroying for the subsequent applicant of, let's say, the same kind of technology?
Look, if it was acquired without his knowledge, then it wouldn't be novelty destroying. But look, the government can only acquire that right if there is an actual patent right, so that patent's being granted. So in that case, there would be a dispute between, regarding the ownership of those rights and who the government actually acquires those rights from. So that is something that would have to be dealt with by the Commission of Patents, where dispute as to the ownership is raised. And also in terms of the revocation proceedings, if a patent right is obtained fraudulently, then the court has the discretion to transfer ownership to the rightful owner in that case. But I mean, whether the government has use or not, who it's from, it doesn't really matter. This would be something between those parties. Does that make sense?
Okay, because I'm just trying to understand, because the section essentially allows the government to order that the patent be kept secret, and allows the government to take the patent and use it for national security purposes. So I'm just wondering about the subsequent applicant for a patent who is not aware of this patent themselves, and a patent that is not going to be published because the provision allows it to be used in secret and for it not to be published.
Okay, I follow what you're saying. Look, I think in terms of those provisions, it would probably be considered novelty destroying, because I guess it would be used on a more commercial scale, to put it like that, or for the defenses of the country. But let me think about that one a little bit more and have a specific look at that as well, and then I'll get back to you on that. Okay. Okay, but then lastly, another exception is that where the invention is being worked in South Africa by way of a reasonable technical trial or experiments. So this is where the party is conducting medical trials, for instance, trials within a lab, where that invention is being used in order to obtain the results. They can't obtain the results without conducting the experiments or technical trials. So those technical trials will then be excused and would not destroy the novelty of the invention. Jeremy, you have a question?
Sorry, just to go back to the previous point, I see where it says the invention in respect to which the patent was granted or any part thereof was disclosed. And then obviously it goes on to speak about reasonable diligence after learning of the disclosure, how you need to apply for protection. But what happens
Yes.
when it is just like a part of it and the full invention itself is not actually yet ready to be patented? Do we have any like case law or anything on what constitutes reasonable diligence? Is it very much a fact and circumstances thing? Because
No,
I mean, it seems a
unfortunately
bit hard.
not. Yeah, it is quite, unfortunately not, but Section 28, I believe it is, also provides for disputes between the parties to, or regarding disputes of ownership to an invention. So I think based on that provision, you would probably need to bring it before the Commission of Patents to decide on that matter and who those rights are then assigned to, who the actual party to that invention is. But unfortunately, there's no real case law that defines what reasonable diligence is in terms of patent law, unfortunately.
Okay, because I was just trying to work out, like, if a part of the patent is stolen, and maybe it's like quite a key component, but the invention or whatever it may be is still a way off from being ready and submitted as a patent in its full and final form.
Yeah.
Let's say maybe there's like another 2 years of R&D which is required or something like
Yes,
that.
yes. I
Like,
completely
would that
understand.
still, yeah.
Yeah, no, I completely understand. Look, and I understand the difficulty because it's not as if you can divide it out, you know, so that one party has the rights only to that part of the invention or not. But I think that would be something that the commissioner would have to decide and possibly even, you know, grant a dependent right to the party that allegedly acquired this knowledge fraudulently. Okay, if we then move on to how the courts will actually assess novelty, what is the test that they apply when determining whether an invention is novel or not? This was very clearly set out in the case of Gentiruco versus Firestone, where a three-step test is applied for the Commissioner of Patents to assess whether the invention is novel or not. So what you'll need to do is first to consider what is the prior art that is available. Although that's not specifically or expressly provided for in the test, it's quite inherent that he would have to, sorry. I don't know what happened to my presentation. There we go. Sorry about that. You know, it's quite inherent that he would have to consider what is part of the state of the art when considering novelty. So and whether something is actually prior art against the invention. But once the prior art has been established, the court will have to construe the claim. So what they'll do is that they'll actually break the claims up into the integers of that claim. So if it comprises of A, B, and C that forms part of the invention, the courts will basically break it up into those integers and compare it to the prior art, as you'll see in step 2. So the prior art then also has to be construed. So it's basically, you know, tick boxes and a checklist, you know, whether the invention comprises of integers A, B, and C, and whether the prior art also includes A, B, and C, as you can see in the third point of the test, where the construed claims that has been divided up into its integers is then compared to the prior art. So if the prior art comprises of A, B, and C, and the invention comprises of A, B, C, and D, D is not necessarily disclosed in the prior art and would still have a novel integer. Okay, so it's basically a comparison of whether the integers of the invention are also available in the prior art document, or whatever the prior art is that the court is considering, and then comparing, whether the integers of the invention and the integers of the prior art do correspond with each other. If it does, then it will be said to be lacking novelty. Okay, and the court will then, award remedies accordingly based on that, and possibly revoke the patent. Okay, what's very important to note is that when assessing novelty, the court can only consider one document at a time. So there has to be a complete disclosure in one prior art disclosure. So it's not possible for a court to consider 5 different patent specifications to find novelty, because patent A might comprise integers A and D, patent 2 might comprise integers C and F. They can't combine these to find novelty. There has to be a complete disclosure in one document for that invention in order for it to destroy its novelty. Okay, good. Okay, so a very important case. This is a very important case in terms of patent law itself. A lot of different findings that came out of this case, but particular because they provided this 3-part test for novelty, where the claims have to be construed and divided into their integers, where the prior art needs to be then construed, and then a comparison between the two to see whether all the integers are are present. Just another consideration in more recent case law, which is the case of Merck-Sharp. This isn't provided in the presentation, but it's a Merck-Sharp Dome Group versus Cipla Agrimed case, where an additional requirement is enablement. So the disclosure in the prior art has to be an enabling disclosure. So it's not enough just to list, and this comes to what we were talking about earlier, Tato. You asked about the cartoon that was considered prior art. If it doesn't provide for an enabling disclosure that enables somebody to actually perform the invention, then it can't be considered as a novelty destroying piece of prior art. And it only seems fair to do so. That you have to be able to perform the invention based on a disclosure in the public domain. I just want to see how we're doing for time. Okay, still got a bit of time. Okay, so that wraps it up for novelty. Are there any questions on novelty? Okay, if we then move on to inventiveness, very short discussion that we'll have on inventiveness, purely because it's such a subjective approach that the court needs to follow when it comes to inventiveness. It's not as with novelty, where it's a comparison of integers. Either integer A and B are present or they're not present in the prior art. When it comes to inventiveness, it's far more subjective. But inventiveness is defined in section 2510 of the Act, that states an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority dates of the invention, part of the state of art by virtue only of subsection 6. So if we just go through that again, it says an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms part of the state of the art. So an invention is only inventive if that invention or the step taken in that invention is not obvious to somebody that is au fait with that specific technology. So whenever the court needs to assess inventiveness, expert witnesses will often be presented to the court that deals specifically to that technology to provide their opinion on whether an invention is, in their mind, thought to be obvious or not. Although the expert opinions is persuasive, the court doesn't need to rely on an expert witness's opinion when considering inventiveness. You know, it's, as I said, it's a very subjective approach or requirement, inventiveness. Inventiveness is also one of the grounds of revocation that's probably most frequently used in practice when attacking the validity of the patent. And the reason for that is because it's such a subjective opinion that the court will follow when determining whether an invention is considered not to be obvious to somebody that's skilled in the art. And if we have a look at what it says in the Burrell's book, it says there is a ground regarding which most more than any other, the circumstances and facts surrounding the particular invention at times far outweigh abstract principles and definitions enunciated by the courts of law under the different sets of facts. So it's very difficult to, nearly impossible to form a general principle as to how the courts need to arrive at an eventual decision when determining whether an invention is actually obvious or not obvious. And obviously it would then depend on the particular facts of a case, but a very difficult assessment to make. But as I said, one that is often relied on when revoking a patent. When a patent is revoked, it will normally be on several grounds. The first ground being that the invention isn't novelty, but then also a second ground that it is not inventive. So in the case of Ensign Bickford versus AECI explosives, the courts did try to set out a test for inventiveness, and this is the test that the courts now follow when determining whether an invention is considered inventive or not. So the court first needs to see or consider what is the inventive step said to be that is involved in the patent. So what is it that gives this invention its inventiveness? They will then also need to consider what the state of the art is relevant to that step and how it goes beyond that step of the prior art. So how does this inventiveness go beyond what is already known, and how is it considered inventive over what the art already is? And then also they need to have regard for the further development or difference and whether that step would be obvious or not obvious to a person skilled in that art. So somebody that is familiar with the technology in question for that invention. Nicole, you have a question for me?
Yes, sorry. In terms of your previous slide, you said that the prior art does not include co-pending patent applications.
Yes.
And secret use on a commercial scale. But previously, when we did the exclusions on novelty, it said obviously that when there is a co-pending patent application or one that was submitted previously, that would obviously destroy the novelty. Or if there is a trade secret that is used in SA, that would also not be considered novel.
Yeah, so those requirements are separate. The novelty and inventiveness requirements are separate. So when a court assesses whether an invention is actually new, those provisions apply. So if the applications, in those instances where there's a co-pending patent application, that is only relative to the novelty. So whether all those integers are disclosed in that co-pending application. But the courts cannot rely on that co-pending application when assessing the inventiveness of that invention. And the same is applicable for secret and commercial use as well. So those those exclusions from novelty are only applicable to novelty and not to inventiveness. So it's a different assessment that the courts will take when distinguishing between the inventiveness and novelty of an invention.
Okay, perfect.
Does that follow? Okay, no problem. You'll see, and it says disregarding subsection 7 and 8, which deals with those specifically exclusions and the inventiveness. Back. So yeah, this is something that I didn't touch on now, is that you know, the state of the art does not include prior South African co-pending patent applications and secret commercial use when the courts assess inventiveness of an invention. However, it does form part of the prior art when the courts are required to assess novelty. And as I said, when a patent is revoked, it's normally attacked on the basis that it isn't novel. But if there is a failure or success on novelty, the party bringing the revocation application will normally include a ground of revocation that it is also not inventive. And then if they do fail on novelty, they will then rely on the inventiveness ground for revocation. So unlike with assessing novelty, where the prior disclosure must be contained within a single document, it is possible to mosaic prior art for inventiveness. So the courts can consider various forms or disclosures relating to that technology, and to see whether, considering all of that prior disclosure, whether it would be considered novel, inventive or not. So for novelty, it's not possible to mosaic documents to find novelty or lack of novelty, whereas for inventiveness, the courts have greater range to consider all of the technology, and it only makes sense to do so, to consider the technology as a whole and to see whether it is inventive to a person skilled in the art or not. Okay, then capable of being used or applied in trade or industry or agriculture. I mean, this is a question of facts. I've never come across an invention that isn't really applicable or that meets this requirement, except for the method of treatment type claims, where it's expressly said that it cannot be considered capable of being applied in trade or industry or agriculture. But something that you can then just read through in your own time and work through. It's, I mean, as I said, a question of facts, very straightforward. One thing that you should also perhaps take note of is that one of the grounds of revocation of a patent is in terms of section 61D, that relates to the utility of a patent, and that it must describe the invention by way of the description itself, the drawings and examples. And if that invention cannot be performed by following the exemplification by way of the description and drawings and examples, then it is said to be lacking utility, and that it can be attacked on that basis as well, that it doesn't have utility in the invention itself. I've got a short snippet here, but I don't know if it will work through the screen or whether you'll have actual sound. We can give it a quick try. Tato, will you be able to tell me if you can hear this or not?
Will do. Can't hear anything.
Jabulani?
Yeah, please, when
It's
you
not
are
good.
playing the video, click there's a button that you click to include audio. When you put your presentation, yeah, there's something that you click like audio somewhere, I don't know. Under file share, you will see it. If you say, yeah, it says include computer sound, just click on that one. Under share content, on your right hand side of share content.
Let's see. Can some of you hear the sound or not? No, no sound at all. Oh, shucks, sorry about that. Sorry, I'm trying to find it. I know what you're talking about. I saw it earlier this morning. I just can't find it now. Sorry for this, guys. You just hang with me for 2 seconds. No, sorry, it seems I can't find it. So I'll give it a miss then. I'll maybe try during our lunch break to see if I can sort that out so that we can have a quick look at this. But what it basically is a snippet from the movie Flash of Genius, where the invention relates to, and this is based on a true story. It was an invention that was created where wiper blades were designed differently. So you've got the motion of the two wiper blades as opposed to the traditional wiper blades that were used at the time. And Ford Motor Company then implemented this technology into their motor vehicles without the proprietor's consent. And they then brought, this is basically the snippet in court where they're arguing the novelty of this invention. And what he's using as an analogy is looking at the dictionary and saying that the dictionary is comprised of all the words and their definitions. But if you take a novel, you know, the same words that are used in a dictionary are used in a novel, but it creates a whole different story. And that was basically the point that I was trying to make earlier this morning, that, you know, an invention doesn't have to be something that's groundbreakingly new. It can be a new method of doing something. It could be something where there's an improvement in a technology, you know, so taking the dictionary, using those words and creating something new from that is still considered to be novelty and or novel and inventive. So it's unfortunate that this isn't working, because it's a good example of the argument that they make. But I'll try and sort that out over lunch and see if I can get it to work. But that's basically the crux of what was going on in the scene over here. Okay, guys, I think we should break for lunch. It's nearly 12 o'clock. Are there any questions that you have for me based on what we've discussed so far this morning? I know it is a lot to take in. It's a lot of knowledge that you need to know, and it might be quite foreign to a lot of the students that are participating in this. But do think about any questions or anything that might be unclear to you now during lunch. And then before we get started, when we return, I'll answer any questions you may have. But please do feel free. Don't be shy to ask any questions if you have any, and I'll try my best to answer them. Are you all comfortable with the pace? Are you all comfortable with how the lectures are being presented? Anything I should do differently, better? No? Okay, good stuff.
Good,
thanks a lot. I think then let's break for an hour. It's now 5 to 12, so we can return at 1 o'clock and then take this further. So enjoy your lunch. I'll see you all back at 1 o'clock. Thanks, guys.
Thank you.
Thank you.
Thank you.
To the guest that's just joined, we're breaking for lunch now, and we'll be back at 1 o'clock. Hi, everyone. It's 1 o'clock now. I'll just wait about a minute or two to allow the latecomers to join into the meeting. welcome back, everybody. I think we can get started then. I don't see anybody joining in at the moment. I've fiddled around with my settings, and hopefully the audio from the video that I was hoping to play for you earlier plays. But just welcome back, and I hope you had a good break. Are there any questions before we get going on with the new section of the work?
I'm good, thank you.
Okay, fantastic. Thanks for Jabulani. Hopefully we'll be able to watch this audio or the video and listen to the audio at the same time. This is that snippet from the movie that we discussed earlier before lunch from the Flash of Genius. So if we can give that a try. Tato, will you give me a thumbs up? Oh, you've disappeared now. If you can hear the audio.
Point. You may answer the question. No. The.
No. Best. No.
Just look. I've got a dictionary here. I haven't checked, but.
Oh no, seems like we lost it at the crux.
But I would guess that every word that's in this book can be found in this dictionary.
Well, I suspect that's probably true.
Okay, so then you agree that there's not probably a single new word in this book.
Well, I don't know, but it's probably true.
All Charles Dickens did was arrange them into a new pattern, isn't that right?
Well, I admit I haven't thought about it in that way.
But Dickens did create something new, didn't he? By using words, the only tools
that were available to him.
Just as almost all inventors in history have had to use the tools that were available to them. Telephones, space satellites, all of these were made from parts that already existed, correct, Professor? Parts that you might buy out of a catalog.
Technically, that's true, yes. But
No further questions.
Okay, so I hope you all managed to see the video and the audio, but that basically conveyed the message that I was trying to pass on to you earlier, that, you know, it doesn't have to be a groundbreaking new technology. It can be something existing that is put together to create something that is novel and both inventive. So we're going to move on to the procedural aspects for the remainder of the afternoon. I think we will end off with the end of this chapter today. As I mentioned this morning, the procedural aspects aren't really the most exciting or riveting part of the work, but it is something that we have to go through, especially the various timelines and processes that are at play for application. Okay, so we're going to quickly run through the process, the overview of how to go about finding a patent application and seeing it through to grant in South Africa. So the scenario that I'm presenting to you now is based purely from a South African perspective. So where you are filing a South African patent application and you're completing it through to grant in South Africa. So generally what happens in practice is that an inventor will file a provisional patent application. Now, provisional patent application is filed to secure that priority date. So again, just to reiterate, that's the date where the first patent application in respect of that invention is filed at the patent office, whether in South Africa or anywhere else in the world. So it's the first application that relates to that invention, and again the date from which the novelty and inventiveness is adjudicated if a patent should ever be questioned in a court in terms of its validity or infringement. So, as I mentioned, inventor will come to you as their patent attorney and request you to draft a provisional patent specification. Now, provisional specification differs from a complete patent specification. Gladys, I can't see your face. There's only some black dots. I'm not too sure if your camera is meant to be on or off. There we go. Thanks. Are there anybody else that wants to show their
Oh,
face?
sorry about that. I don't
No,
know
that's
because I try to, it's on, but I don't know what's the problem. Maybe
It's okay, no problem. Thanks, Gladys.
me and technology. So but
That's no
I'll
problem.
keep on trying.
Thanks, Jacques. Thanks, Jabulani. Thanks, Gladys. Okay, so as I was saying, a provisional specification differs from a complete patent specification in that the provisional application only needs to provide a description of what the invention is. Whereas with a complete patent specification, a set of claims is included. And you'll recall from earlier this morning, the claims are what define the scope of protection. So when a court ever has to adjudicate on a patent, they will look to the claims to assess what the scope of the monopoly is. So the invention is defined in the claims, whereas the rest of the specification will describe or exemplify the invention itself, setting out how it works and how to go about achieving the results that it sets out to fulfill. So for the provisional, it's not a requirement to file a set of claims, but only the description of the invention itself. It's not necessary to file a provisional specification. It is possible to file a complete specification without filing a provisional patent specification. The reason why the provisional application is filed is in order to secure that date of priority, as I mentioned earlier, and to buy the proprietor of that invention a bit more time to either further develop the invention, because you must remember in practice, a lot of the work that's undertaken is a very theoretical nature. And you'll recall that I said a patent specification must sufficiently describe the invention in order for somebody that's skilled in that art to enable them to actually perform that invention later on. So at this stage, it could be that it's a very theoretical form of work where the invention is described. And further time might be required in order to fulfill further research and development on the invention itself. It might also be a reason for the patentee to file a provisional application in order to secure some time to find funding, to go to investors, to be able to bring this product onto the market eventually and to commercialize the invention that is the subject of this application. So it's twofold. It's to secure that filing date to ensure that you have that date of priority. So any invention that is filed after the priority application will not be considered prior art against the invention in terms of novelty and inventiveness. And then secondly, it also is used to secure the applicant more time to either fulfill some further research and development to ensure that any tweaks can be enhanced or tweaks can be made, and to improve on what has been described in the provisional application. So once the provisional application is filed at the South African Patent Office, just before I continue, no granted rights stem from a provisional application. So provisional patent application doesn't grant the applicant any rights. It does provide them with that priority date, however, but it's not something that you can use as an enforceable right against a third party should they be infringing your patent. So once the provisional application is filed and you wish to further the application and obtain granted rights, you have to file a complete patent specification. This has to be done within 12 months from the original filing date, so the filing date of the provisional application. So within 12 months, as you can see up at the top here, let me get my laser painter. Okay, so you have 12 months within which to file the complete application.